Good evening to one and all. On the IP day, I would like to speak a little bit on artificial intelligence and intellectual property rights. As we know that artificial intelligence is a wide-ranging branch of computer that is concerned with the building smart machines that are capable of performing tasks that require human intelligence. Or, in other words, artificial intelligence refers to the imitation, replication of the human intelligence in machines that are programmed to think like humans because they impersonate like human actions. And IPR, that is intellectual property rights, they are the legal rights governing the use of creations of the human mind. According to TRIPS, the intellectual property rights are copyright and related rights. Copyright that protects the written or published works such as books, songs, films, web contents, and artistic works. Then, if we see patents, then this protect commercial inventions, for example, a new business product or process. Then right of the traders in their trademark are also protected as intellectual property because this protect the signs, symbols, logos, words, or sounds that distinguishes your product and services from those of your competitors. Like trade secrets are there, plant varieties are there. So there are many intellectual properties which are to be protected as a legal right. If we see the 2019 report, which is published by the World Intellectual Property Organization, discussing the trends in patent applications and grants, that is available on the government websites. There has been a rise in the artificial intelligence related applications in the field of telecommunications, transportations, life, and medical sciences. And these patents have involved technology relating to natural language processing, speech processing, and computer vision. So, AI, this artificial intelligence, and IPR, intellectual property rights, they are two interrelated concepts in today's digital era. Because AI technology advances, it is increasingly creating new challenges for IPR protection. Firstly, we see that artificial intelligence is creating new works that are eligible for protection under the copyright law, and it is creating new challenges for the copyright law. For example, if I say that an AI system may create original music or it may create art also, and the question arises as to who owns the rights of these works. And we know that these are the works that are eligible for copyright protection. Now, suppose if an AI system is trained on a database of images, and then that AI creates a new image that is similar to the image in the data set, but it is not an exact copy. So, this new image may be eligible for copyright protection. And the question again is the same: who owns the copyright in this new image, which is not the exact? So, in general, copyright law grants the copyright owner the exclusive right to reproduce, to distribute, and to create derivative works based on the original work. However, in case of AI generated works, it may not clear who the copyright owner is. If the AI system was created by a human being, then the copyright in the AI generated work may belong to the human creator. However, if the AI system was trained on the dataset of copyrighted works, then it may be argued that AI generated work is a derivative work of the copyright works in the dataset. and the copyright owner of the data set may have a claim to the copyright as it is in the AI generated work. There is some other challenges also regarding the determination of the level of originality that is required for an AI generated work to be eligible for copyright protection. In general, we see that copyright law requires that a work to be original in order to be eligible for the protection. However, it may be difficult to determine how much of the work was created by the AI system and how much work was created by the human creator who trained the AI system. Another way is that AI is being used to assist in the creation and management of IP assets, such as the patents and trademarks. That is to say, AI is also impacting the creation and management of the patents and trademarks. So, AI can help in the identification of the prior art and assist in the drafting of the patent claims. For example, if I say that an AI system can be trained to analyze a large data set of the patents and identify the patterns in the language used to describe the different inventions, this can help the patent examiners to identify the prior art more efficiently and more effectively. Similarly, AI can assist in the management of trademarks also. For example, if I say that if an AI system can be used to analyze the large data sets of trademark registration to identify the potential conflicts between the trademarks. So this can help the trademarks owners and attorneys also to make more informed decisions about the registration and the use of the trademarks, because there is a risk that AI may unintentionally infringe uh, an existing patent or trademark. So this can occur if the training data used to develop the AI model contains patented or trademarked inventions or logos. And we can say there is a risk also that AI generated inventions may be considered obvious for lacking in inventive steps also, which could make them ineligible for patent protection. So this can occur if the AI system simplify, identifies and combines the existing interventions. And in such a way, this invention has to be identified that is obvious to a person skilled in the relevant field. However, AI is providing new tools and techniques for creation and management of patents and trademarks, but there is also challenges associated with the use of the AI in the areas like trademark, patent, and copyright. And I suggest that policymakers need to address these challenges in order to ensure that the patent and trademark system remain relevant in the age of artificial intelligence. There is one more point to discuss, that is, AI technology can be used to identify and enforce IPR infringement. AI can analyze large amounts of data to identify potential infringers, and that can also be used to automate the monitoring of online marketplaces uh, for counterfeit products. So, IPR infringement can occur in various forms such as copyright infringement, trademark infringement, and patent infringement. And AI can be used to identify and enforce IPR infringement in several ways, like image and audio recognition, because AI based image and audio recognition technology that can be used to identify the unauthorized use of the copyright images or audio files. For example, if AI system can compare images or audio files available on the internet with copyrighted images or audio files to identify any unauthorized use, then natural language processing NLP, that is a branch of the artificial intelligence that focuses on the interaction between computers and human language. So NLP involves teaching computers to understand and interpret natural language inputs, such as the text or a speech. There are several ways in which NLP can be used in the field of IPR. For example, NLP techniques can be used to analyze patent documents, to identify similar or related patents, or to extract the key information from large sets of patent data. NLP can also be used to analyze trademarks and identify potential conflicts with existing trademarks. So, NLP technology can be used to identify trademark infringements by analyzing text. Additionally, we can also see that NLP can be used to analyze social media posts or online reviews for potential trademark infringement or copyright violations, because this procedure of NLP, this process of NLP, that can help the streamline the process of researching and analyzing intellectual property and provide valuable insights to the legal professionals and IP owners. Then there is one more method through which we can take the help of using this AI in the area of IPR, that is predictive analytics. Predictive analytics is a branch of data analytics that uses statistical techniques, machine learning, and data mining to analyze the historical data and make predictions about the future events or the trends. So this predictive analytics can be applied to various fields that includes intellectual property rights also. And this predictive analytics can be used in IPR to help companies and individuals that can make more informed decisions about their intellectual property assets. So AI powered predictive analytics can be used to detect potential IPR infringements before they occur. For example, if we see that predictive analytics can be used to analyze the patent data and identify trends in patent filing or technology developments. So this can help the companies they may come with more informed decisions about which patent is to be filed, what technology is to be invested in, and which markets are to be targeted. So by analyzing the historical data, AI can identify the patterns and trends that may inculcate that also that may indicate some future infringement. But one thing is important to mention, that predictive analytics cannot replace the expertise of legal professionals in the field of IPR. So, overall, artificial intelligence can be a valuable tool in the fight against IPR infringement. However, it is important to note that AI should not be relied upon as the sole solution to IPR infringement. Human expertise and judgments are still necessary to ensure the accuracy and fairness in enforcing IPR laws. However, there are also challenges which are associated with the use of the IPR and the use of the artificial intelligence. But we have to see that there is a risk that AI may unintentionally infringe on the existing IPR, especially if the training data used to develop the AI models contains copyrighted works. So finally, AI is having a significant impact on the IPR, and it is creating both opportunities and challenges for IP owners and policymakers. As AI technology continue to evolve, it is likely that the relationship between AI and IPR will continue to evolve as well. So, and we think we have to think in the line with the rejection of patent application filed by an AI inventor. You may be aware that in 2017, an AI system named Davos was named as the inventor in patent applications. And these applications were filed in UK, USA, and Europe. However, The same was rejected in all the three jurisdictions on account of it not being a legal person, as required by most of the intellectual property rights regimes. So we have to think that how far these AIs are helpful in protection of our IPRs. At the same time, the human mind, the human being cannot be impersonated by the machines. Thank you very much.